Hello and welcome to the November edition of Landlord Law Firm's Landlord Advocate video newsletter. I'm Robert Chesson. In this edition of our newsletter, we're going to cover what is becoming the hottest topic that we have conversations with clients about throughout the state of Connecticut, and that's emotional support animals. This edition will be our second installment in our series on fair housing issues. A brief disclaimer before we get started. It is impossible for us to cover the issue of emotional support animals here in the newsletter, but we wanted to touch on a few topics to make sure you were prepared for the inevitable expectation that you're going to face one of these requests. The most important issue around emotional support animals is to understand that your pet policy in your community is ultimately not applicable to an emotional support animal. That doesn't mean the entire policy isn't applicable, but for example, if you have a no pet policy, that does not prevent you from allowing a emotional support animal into your community if a request is made for reasonable accommodation by one of your residents. And equally as importantly, if you do allow pets, but you have pet fees, pet deposits, or any other costs associated with allowing pets in the community, those fees must be waived when you're dealing with an emotional support animal situation. You can still apply various caretaking and cleanliness responsibilities to anyone who has an animal on the property. Obviously, if you have a no pet policy, you may not have such rules and regulations in place. And so if you're faced with a request for an emotional support animal, you may need to implement certain policies and rules associated with allowing those animals on the property. Second item we'd like to highlight is the fact that although service animals by law are restricted to dogs or miniature horses, in the emotional support animal arena, there is no expectation or limitation on the breed or variety of animal that could be considered an emotional support animal. We've actually seen requests for dogs, we've seen requests for cats, we've seen requests for pigs, we've heard of requests for turkeys, we've heard of requests for goats, and we've actually seen the request for an emotional support duck. And probably the most common emotional support request we see is a request for a dog that is otherwise a restricted breed on the property. And lastly, if you don't currently have a policy surrounding requests for reasonable accommodation, you should consider getting one of those in place sooner rather than later. It will be much easier and to your advantage to have that policy in place long before your first request. And you can be certain that anytime you get additional requests, you follow the same policies and procedures so you don't find yourself facing a fair housing claim simply by treating two different requests with different standards. If you face any one of these requests, as always, we recommend you consult with your landlord attorney to make sure you're getting good advice on how to deal with that request. I hope this was helpful. Thank you again for joining us for this month's edition of the Landlord Law Firm's Landlord Advocate video newsletter. I'm Robert Chesson. We'll see you next month.